Hello, my name is Lee Presser. This is my show. I speak frequently to very interesting people. Some of these conversations are so exciting, so intellectually stimulating, I thought others might like to listen in. This is the reason we started recording Conversation with Lee Presser.
Welcome to Conversation with Lee Presser. Judge Daniel Ramczyk wrote earlier this year, "It is a judge who determines the facts of a case based on all relevant and admissible evidence and who correctly applies the governing law. A trial judge's limited discretion and power ensures impartiality and fairness. His or her factual findings must be supported by admissible evidence, and the judge must follow the laws passed by the legislature. If a trial judge fails to do that, he or she will be reversed by an appellate court. Count on it." Our guest today is Steve Korris, courts reporter for the Madison-St. Clair County Record, Metro East legal newspaper. Mr. Korris is here today to discuss the ethics and fairness of judges in our local courts. For those of you who do not know this, circuit judges are elected or retained by the voters. Associate circuit judges are appointed by the circuit judges from a list of qualified applicants. Even-handed treatment by the courts of litigants and persons accused of felonies and misdemeanors has become an issue of national discussion. We're going to talk about that during this half hour. Steve Korris, welcome to the conversation.
Good to be here.
Plus some other stuff too that you just brought to my attention. What I was thinking about when I wrote that introduction was several things that you and I had talked about in terms of fairness. The first thing we're going to mention, and we're just going to briefly glance over that, was last time you were here, there was a discussion about 3 judges in St. Clair County who, quote, resigned their seats and are running for election rather than running for retention. Just briefly, in about 1 minute, just describe where that stands and what that's all about.
The 4th District Appellate Court in Springfield heard an appeal of a circuit court order in favor of those 3 judges, and the 4th District affirmed the lower court decision, which had affirmed the election board decision. And so unless the Illinois Supreme Court changes that whole pattern, they will be allowed to run as new partisan candidates rather than stand for retention on a nonpartisan basis. They'll need only 50% instead of 60%, and we don't know when the Supreme Court might deal with this.
So that's the deal. The Illinois Constitution says that judges are supposed to run for retention, not election, and to be retained they have to get at least 60% of those who vote for judge to vote yes to retain, right?
That is correct, and the Constitutional Convention of 1970 set that mechanism up very carefully, and it's collapsing down.
Right, so now based on the decision of these 3 judges in Belleville, that there probably won't be another judge running for retention. They'll all just resign and run because they only need 50% instead of 60% because judges have become controversial instead of not controversial.
That's correct, and the lawyer for the objector made that point at the appellate court, that why would a judge run for 60% when he could run for 50%? But it didn't persuade them. And right. Those judges who entered that opinion, get the benefit of it. They gave themselves the right to avoid retention.
Oh, I hadn't even thought of that, but you're right. That's right.
And the Illinois Supreme Court justices, too. It will be their decision for their own selves, as well as for everyone else.
So they're actually voting to change the Constitution, in essence, without actually changing the Constitution.
For their own benefit.
For their own benefit, right. Okay, so we've done due diligence there. People can look at this and then go like ho-hum, but it's really actually very important, isn't it?
Tremendously.
But people are lazy. They won't even bother to even really do anything about that or even question it.
I don't want to predict November.
Yeah. Then, there's at least one of those judges that doesn't even have an opponent, right?
That's correct.
So he's already elected.
Yeah.
He gets 1 absentee vote and he's in.
Yes.
Right, okay, so I'm right. Now, there is a fella who has, and you're going to tell this story, but apparently he, as a judge, has ruled in favor of Southern Illinois University system. Tell the story.
Judge Phil Gilbert of the Southern District of Illinois, who usually is in Benton, Illinois, was appointed by Governor Rauner to be on the SIU Board of Trustees. And we thought it was unusual, but we didn't really make a story out of it. And then earlier this year, a lawyer filed a complaint alleging that he should not have both roles. And the Seventh Circuit Appellate Court in Chicago had to decide how to handle this, and they ruled that he could have this dual position as judge and university trustee, and that the conflict of interest wasn't a problem.
Well, first, describe the conflict. What was the conflict?
He could no longer hear cases involving the university.
But he had previously. So he had ruled for SIU on 7 occasions?
We went back and looked, and the last 7 cases that came before him, he ruled for the university.
And then now he sits on the board.
And now he's on, and this lawyer who complained wanted him kicked off of the SIU board or kicked out of the court. And so the Seventh Circuit came up with this explanation, and part of the explanation was, what I didn't know, his grandfather was a professor at SIU, and his father, as a state legislator, obtained the funding to turn that little teacher's college into the giant institution it is today. So they stressed this sentimentality, and they wrote that Judge Gilbert was eager to serve SIU. Those are their words, not mine. And that sort of cast a cloud over everything that had happened before, so we pulled the cases, and it was 7 for 7. Mm-hmm. And one of them in particular got a Seventh Circuit dissent that was very harsh, and that case was a 79-year-old professor harassing an 18-year-old student, and Gilbert and the Seventh Circuit kind of said, well, it's okay. The university responded reasonably. So all those cases look kind of strange in retrospect.
That's what I was just going to ask you, if there was anything untoward about his decision. I mean, there are some decisions that it's like, pro forma. I mean, judge looks at it and goes like, yeah, well, the university's right on this, right? But you just said that maybe it wasn't so pro forma. The university might not have been right, but we still support the university, and then we get a reward.
Right.
Now, I don't want to make any assumptions, assertions, or anything here.
That's why we just ran the record, and it's a much longer story than we usually have, so that we could tell all 7 stories and let the reader think about it. And 3 of those 7 decisions were appealed to the Seventh Circuit, and they affirmed all 3, including this one that brought a dissent. And in justifying Gilbert, they justified themselves.
These are all state courts we're talking about.
No, I'm sorry. This is U.S. District Court and Seventh Circuit Appellate Court in Chicago. I'm sorry. Federal court. Yeah.
Federal court. It's moved to the federal level, and they're still affirming all this.
When it got up to the Seventh Circuit, 5 days after Rauner appointed Gilbert, the appellate court affirmed a decision he had made in favor of SIU.
Okay. Has anybody asked the governor? Have you asked the governor, or anybody in your organization asked the governor any of these questions about why they would pick a man who is in a position to vote yes or no about SIU and for the board?
No, because we relied on the Seventh Circuit in charge of the court, and they were saying, this is great. Grandpa, Daddy, this is wonderful. And so we just laid it on them. No, we didn't ask Rauner. The decision that was affirmed after his appointment, he issued in the summer of 14 when Rauner was running for governor. So you can't undo any of those decisions, I don't think. But to see the whole pattern, it just makes me uneasy.
Mm-hmm. And that's your job. You look at legal cases all the time.
Right, and I had to boil all 7 of these cases down to a length that the reader could try to figure out. But the facts are right there, and I hope a lot of people read all 7 summaries.
So, but you have no or do you? Do you have an axe to grind in this? I mean, do you have any personal ambitions, or you know these people, or you want to hurt the judge, or you want to hurt SIU for any reason?
No, I could stress sentiment too. Brother and sister graduated from SIU. I've been to countless sports events at SIU. We just blow the whistle on what we perceive as injustice wherever it pops up. Mm-hmm. And those words, eager to serve SIU, the first time I read those, I kind of went, yeah. And the more I thought about them, the more I thought, that's what he's been doing.
Mm-hmm. So in your opinion, in your personal opinion, and your professional opinion, you feel that a judge who has been involved in SIU cases should not necessarily also be on the Board of Trustees of that same institution.
And that he should...
And be both. He's still the judge and a trustee.
He never should have been on any of those cases. 2 of those cases were originally assigned to other judges who disqualified themselves. Mm-hmm. But judges never have to explain why they do that, and you can guess, you can use circumstances, but you never know. But how could their conflicts have been deeper than the daddy and the grandpa thing?
That's a very good point you make. So you published this?
Yes.
And so people have only to go to your website, and then they can read about this themselves. Your website is put up on our screen intermittently so that people can see it, and they can copy that down or type it in their computer right now. And this program is also on YouTube so that people really worldwide, but across the country, can be looking at this and get some idea of what's going on in Southern Illinois. So let's move on to yet another interesting case, one that you just brought to our attention here just moments ago before you actually came on the set. I've set you up, now you go ahead and tell the story.
Well, the best part of my job is the moment of discovery, and yesterday morning I found that last Friday the 5th District Appellate Court ruled against Madison County.
Now that's an Illinois court, right?
Right, in Mount Vernon, the State Appellate Court. They reversed a Madison County Associate Judge, Stephen Stobbs, and they ruled against County Board Chairman Dunstan, County Administrator Parente, for kicking the Veterans Assistant Superintendent out of the court administration building. Bradley Levitt is his name, and Parente issued an order keeping him out of the courthouse about a year and a half ago after he had an unfortunate, I guess what we would call a flashback.
He is a veteran himself.
I'm sorry, he is a Bronze Star veteran. The Veterans Assistance Commission hired him in 2009. They love him, and they stood by him through all of this.
Mm-hmm. And he works in the Madison County Courthouse building.
Yes, a small little office. There's the courthouse and the administration. He's in the administration.
Oh, he's in the administration building. Mm-hmm. Okay, which is next door.
So this flashback got so intense that he kicked the windows out of a Wood River police car. Now that's hard to justify, but
that's not good.
Is it a reason to tell him he can never come back to his job? Mm-hmm. And so when he sued to be let back into his office, Judge Stobbs, Dunstan and Parente moved to dismiss it. Judge Stobbs granted that motion. So then on appeal, the appellate court not only reversed Stobbs, but they really hammered him and the county for their positions and for the condition of their litigation.
And that's these papers right here.
And here's the appellate court decision. And at the very day, last Friday, that the 5th District upheld him, his lawyer filed a lawsuit in federal court against Chairman Dunstan, Administrator Parente, Sheriff Lakin, and State's Attorney Gibbons.
Mm-hmm. And this is for money damages.
Yes, and this one takes the retaliation back, the alleged retaliation back, before the Wood River episode. He claims it started when money he had raised for veterans was spent sending judges on a trip to California. And he protested against it, and he alleges now that that's when they started retaliating against him. There are no details about this California convention, but we will do our best to find out who went and what it cost.
Okay, just personal disclosure. I know this man. I have had dealings with this man myself. As a veteran myself, I needed some help, contacted him, and he was very helpful, got it taken care of in a very short period of time. He, vet to vet, he did me a service. I don't know anything else about him other than that one incident that I was involved in. But it is surprising that what you're telling me.
And the law that the 5th District relied on is extremely clear. These Veterans Assistance Commissions are set up to be separate from the counties in which they operate, although the law requires the county to have that operation inside of its building.
So they have to provide
they have to provide him the space, but they pretended in the circuit court that they were his employer, and they weren't even right about that. And much of this decision relates to, no, he doesn't work for you. You can't impose your rules on him. They even tried to apply county competitive bidding ordinances to keep him from having his own lawyer in this. And the 5th District said the county's competitive bidding does not apply to this independent, separate commission.
Mm-hmm. Now, as I said in my introduction of this discussion, that there is, since the Michael Brown incident in the United States, there has been considerable discussion. So we're now talking 2 years that this has been going on. There's been considerable discussion about the fairness of the legal system, the fairness and even-handedness of judges, depending on who is a plaintiff or a defendant before them, and whether or not judges can actually be counted upon in order to dispense fair and even-handed justice. These two cases or three actually, but these two cases that we've just discussed make the very point that there might be issues that need to be dealt with.
Well, and some of this is so absurd that it's almost funny, but
not to Brad.
No, in criminal cases, it's hideous. Michael Cook, prior to resigning and going to prison, presided over...
Tell people who Michael Cook is.
I'm sorry. St. Clair County Circuit Judge until 2013.
Who got caught.
Got caught possessing heroin. And using it while possessing firearms.
Right.
It was a misdemeanor, and he was sentenced to 2 years.
Misdemeanor, heroin and firearms, judge.
Right.
Right. And heroin while actually in his office. I mean,
yes.
Sitting before people who were being heard, he was high.
And we continue getting decisions from this same 5th District Court reversing decisions that were made in his court where he paid absolutely no attention to rights and procedures. And Judge Barasevic, the Chief Judge of St. Clair County, has been reversed twice in the last 60 days for conducting criminal trials in a fashion so sloppy that it violated the rights of the defendants, one at jury selection before the trial, one at jury instruction at the end of the trial. He just kind of ran through it in a haphazard manner. No respect at all for the rights of these criminal defendants.
I know John Barasevic. This doesn't sound like the John Barasevic that I know. But the circuit or the appellate court found it that way, right?
Mm-hmm.
So what is going on? I mean, you deal with these judges. You deal with these cases on a regular basis. You see them when they're newbies just coming in. Is it something that do they come in with the right attitude and then suddenly it deteriorates over time, or did they not have the right attitude or the right person put in there in the first place, or what's your assessment?
A person recently described a condition called judgeitis. He said, you've seen the lawyers at the bench. You've seen how they laugh at the judge's jokes and yes, sir, Your Honor, yes, Your Honor. He said that it's a common ailment, judgeitis. Also, our society has made judges by far the strongest people in our society. All decisions wind up before them. All legislation is interpreted and pretty much refined by them. And yet...
By the way, Jefferson warned about that. He warned about it loud and clear after he left the presidency, saying that the judiciary is gathering far, far too much authority into their hands and will soon do what you just suggested.
And a certain amount of courtroom conflict gets covered in the news. But by and large, news professionals still focus on the legislative body, city council, Congress, and the executives. Coverage of courts is extremely weak, and so there's very little accountability, and that's why my editor and I try so hard to bring a little accountability.
And that's why retention votes rather than election of 50%. In other words, these judges have to be so good that at least 60% of the people say, yes, we want to keep them.
That's right. 2 years ago, Illinois Supreme Court Justice Lloyd Carmeier had to stand for retention, and 2 or 3 weeks before the election, the opposition came at him with a TV blitz, and it came down to the wire, and he was retained by like 300 votes or something. It was razor thin.
And he's a Republican.
He is. And the money against him came from the Democrats, who did not have a candidate because it was retention. So he was held to that 60% standard. And amazingly, with all the ammunition that was spent attacking him, he still hung on. And that was a real test of our democracy, and we're not going to see that anymore.
Now, you mentioned John Barasiewicz. John Barasiewicz is one of the 3 names that we haven't named here from the very beginning of our conversation. He's one of the 3 who decided to, quote, resign and then stand for election. Now, I find it interesting. I like John. He's been here as a guest. But I just find it amazing that one can resign a year from now. Hey, I'm resigning. Oh, but not for another year. I'm going to continue to hear cases. I'm going to continue to do this. And as soon as I'm reelected, then I'm not really resigned after all, am I? But if I don't win, then it doesn't matter that I resign because I'm out of office anyways, right? Is that what we're saying here?
Yes. And, you know, there's the old stereotypes about lawyers being able to craft any kind of argument at all. Well, here you got judges crafting an article, crafting an interpretation of an article of the Constitution in a way that only one person ever had done. There was one case where no one objected and it happened. But only once in 46 years has this happened, and now all of a sudden they're saying, oh, but see, it's here, we've got it, we can do it.
The camel's nose. The camel's nose. Now we got about 5 minutes left here.
All right.
So what have you got for us to cover the next 5 minutes?
Well, we didn't talk about the Madison County asbestos judge that's still an asbestos lawyer.
Oh, yes, that's right.
Associate Judge Donald Flack, who became an associate judge 4 years ago, and in the weeks leading up to his appointment, he put 30 asbestos lawsuits into the county court.
Now let's remind people what I said at the beginning. Associate circuit judges are actually appointed by the circuit judges from a list of qualified candidates. So Mr. Flack was Attorney Flack and then put his name on this list, and the circuit judges picked him to sit under them basically as an associate, right? Okay. And this period when they were picking him, you're saying he was doing what now?
Filing asbestos lawsuits in Madison County Courthouse, where there are maybe 1,000 that are filed every year.
Madison County is like, if not, it's the #1 asbestos courthouse in the entire country, right?
And just The docket of the first case, he named 119 defendants, 70 of them, no, 119 is the fee. He named 80-some defendants. 70 of them paid their fee to defend themselves. You can't defend yourself in Madison County until you pay the fee, 119, so that's $8,333 that the county made off of this lawsuit, and he filed 30 of them. That's $250,000 roughly that he generated for the county while he was waiting to become an associate judge. And three of those lawsuits were filed after his appointment, but before he actually went on.
Mm-hmm.
So,
now from your perspective, something wrong with that?
Yes, because he still has an interest in those cases. He did not clear himself away from them. Is
his name still on these cases?
No. Well, actually, technically, yes. You enter your appearance and then you withdraw it, and he filed complaints without entering an appearance and then didn't withdraw his appearance, and we've been unable to get an answer from the clerk's office about what the official standing is. But he put these cases down on his economic interest statements.
But he's not hearing these cases, right?
No, right. Judge Staub's and associate judges. The question is, until we found it, did Judge Staub's know that he was about to have a hearing and make a ruling on cases that his colleague has an interest in? He should know that, and I don't know what he should do at that point. But to have an asbestos lawyer with, every year he lists his law firm as a source of income, to have asbestos cases coming through making money for him, apparently, almost certainly, while he's a judge in the asbestos court of the nation, it just doesn't feel right. No, in one case we did find, not an asbestos, a separate one, where he specifically did withdraw his appearance. In federal court, they're much stickier about this procedure. He withdrew his appearance 3 days before he became a judge, but a year later, he put it on his disclosure form as a case he had an interest in.
Now, this is not the first time that asbestos has come to bite a judge. I remember, this is not that many years ago, where there was an asbestos lawyer that was giving money to a judge who was hearing asbestos cases, and the judge was accused, and we've only got like 30 seconds left, the judge was accused of being the one to put on the docket those cases.
Yes, it was open and shut.
And the judge was removed from
the judge was removed from the asbestos court. However, when it had happened 6 years earlier with Judge Nicholas Byron, the exact same thing, nobody uttered a peep. And I think that's to the credit of the Madison Record and my editor, that it could withstand the light of day before, but not after.
Right. Thank you.
Thank you.
Yeah, well, you've been hearing, I don't even know what to say at this point. Steve Korris, he's a legal reporter. He's brought us some very interesting information. I hope that you've listened very closely. We're putting this up on YouTube. Show it to your friends so that they know what's going on in the courts. See you next time. Thank you. Goodbye.